The reduced cost of an intelligent justice comprehensive adjudication proceeding can often be financed by litigation finance providers that only require repayment of the loan if the party they are financing wins the case. They prefer comprehensive adjudication because they can recover their finance fee in half the time and with half the investment required to finance the same litigation in the public courts.
Hello, my name is Rick Grossman. I'm the founder of the nonprofit Intelligent Justice. In this video post, I will explain how litigation finance providers can be utilized to fund the claimant's half of the comprehensive adjudication's cost on a contingent fee basis. In prior posts, I have explained how comprehensive adjudication makes it possible for all parties to a dispute to jointly retain a distinguished legal professional with expertise in the relevant area of law to vigorously investigate the law and evidence supporting both sides and decide the dispute at less than half the cost of retaining separate counsel to litigate the same dispute in court. The cost savings is achieved by splitting the cost of the jointly selected adjudicator's hourly fees. However, some claimants would prefer to finance their claim on a contingent fee basis, where they pay nothing if they lose and pay a percentage of their recovery if they win. Of course, a jointly selected adjudicator must remain neutral and cannot have a financial stake in one side or the other winning. But independent litigation finance providers are eager to finance the claimant's half of the adjudicator's hourly fees on a contingent fee basis, and frequently will charge a substantially discounted percentage of the claimant's recovery if comprehensive adjudication is utilized instead of litigation in a public court or conventional arbitration. Litigation finance providers favor comprehensive adjudication because if the claimant wins, their return on investment is dramatically higher than a recovery via litigation in public court or arbitration. When the parties utilize comprehensive adjudication, the litigation finance provider has an opportunity to obtain its desired contingent finance fee in less than half the time and with less than half the investment required to finance conventional litigation of the same dispute. This opportunity for litigation finance providers to dramatically increase their return on investment in meritorious claims makes it more likely they will agree to finance claims they might refuse to finance if the claim were to be litigated in court or arbitration. In many instances, litigation finance providers will agree to finance the claim charging their regular percentage of the recovery if the claimant wins after utilizing conventional litigation, and a discounted percentage of the recovery if the claimant wins after utilizing a comprehensive adjudication proceeding. Of course, as always, the litigation finance provider must be selective about the claims it finances because it will not obtain any fee at all if the neutral adjudicator decides the case against the claimant whose legal costs they are financing.